it to trial. Take it to trial. Welcome in, grab a seat, hit the like and subscribe. Cause Sweet P's on the mic with that spicy little vibe. Got the courtroom streaming in the chat, going wild. We're debating heavy topics, but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when Sweet P's in the building, we be learning with pride. My eyes on deck, keep the room running smooth. Film freak therapist, you know, keeping everyone in the groove. Right to with the facts, pretty brown girl with the sass. Moreldia and Fowler keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate, take it to trial, where the truth gets loud and the laughs run wild. Sweet P's got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know Sweet P breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you're out of line, court adjourned for the day. But when Jason logs in with that deep hello sound, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. Sweet P's got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. When the sun goes down and the cases get deep, after dark gets spicy, no secrets to keep. Taboo topics, big laugh, slap, happy crew. Sweet P says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made a goal. Hey! Take it to trial, from day to night and every wild mile. Sweet P's million strong with her trademark style. And the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight. Take it to trial, yeah, we live tonight. Take it to trial, yeah, we live tonight. Take it to trial.
Oh, you probably couldn't hear me. My bad. I wasn't added to the stage. I'm just sitting up here talking and talking and talking and talking. Thank you, Martina. I'm so glad you said, are we stuck? Because I'm like, I'm not stuck. Is she stuck? Oh, boy. I've been talking all this time. No worries. I wasn't saying nothing. Nothing important. Yes, I was. I was saying some things important. I was just saying, I didn't know how many of you have followed this trial, but we kind of were in and out of this trial. When it came out, we were like in the middle of 3 trials. So we didn't follow it really, really closely, but we did get to meet Sparky. And we could see her over here in the courtroom. She's in there right here in the white. So we definitely got Sparky here. So she's in the house. But I did want to give people a brief recap before we go into the trial. Hey, Susie. Good morning, Martina. Anybody that is lurking. Good morning to you. Good afternoon. Good evening, depending on where you at. So, okay, SweetPGang, before we get into these trial arguments, I just want to catch us up, right? For those that haven't seen it, we are talking about New Jersey versus Paul Caneiro. The case, I guess it's really, really bad because remember, this is all his, well, if you don't know, this is all his family that he unalived. So back in November of 2018, authorities responded to a house fire at Paul Caneiro's home, right? The person that's on trial. At first, it looked just like a fire, but very quickly, things didn't add up. What investigators discovered at the time, that same day, Paul's brother, Keith Caneiro, his wife, and his 2 children were all found unalive inside their home, which had also been set on fire. Yeah. So now authorities had 2 fires, 4 victims, and both scenes connected to the same family, which is, I don't know if you can call that coincidence or not coincidence or what that is. Like, come on, really? So he was charged with 4 counts of first degree murder, arson, weapons offenses, and other related charges tied to the investigation. Now, remember, Paul and his brother and Keith owned a business. They were very successful, but Keith had decided that, due to things changing in the market, that he kind of wanted to, dissolve his share of the business, which would put Paul in a predicament because Paul hadn't gotten his stuff together or kept his stuff together for this day. So I guess in order for his brother not to make those changes, he unalived them. So, he recently had his trial. It was in February, I believe, and Paul Caneiro was sentenced to life in prison without the possibility of parole. Now, that means that he would never be released, and he will most likely spend the rest of his life behind bars. Now, the reason why we are here today is because the case is not completely over because, as always, they always asking for appeals and requests for a new trial, blah, 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 blah. So what his defense team is saying is basically something went wrong during the trial and he deserves another chance in court. He deserves another shot. So the real question now just becomes like, is this a real legal argument? We do know everybody is requesting a new trial. All right, guys.
I'm going to pass it along on behalf of Mr. Faulkner, who's my.
Morning, Judge Amy Murray, also for Mr. Caneiro.
All right, good morning, everyone. All right, so I had my law clerk send an email to you all so that you would have a good idea the way that I wanted to structure this motion, making sure that counsel had enough time to argue their motions, but to remind everyone, which I've done throughout this entire case, is to let everyone know that the briefs that were filed, the brief by the defense on March 16th, the state's response on April 6th, including the appendix from the defense's brief, that's all incorporated into the record. We do not need to re-argue that because I've read it many, many times, both sides, so I don't want to do that. What I'm going to do is, as I'm going to structure it is that I'm going to give each side an hour to make their arguments. However, I want you to know in advance, the way that I have it structured in my brain is I'll give you a couple minutes to make some comments, initial comments that you want to make. But I have, based upon the briefs, based upon the record, I have a significant number of questions to ask both sides. So it's not going to be a full-on just argument. It's going to be a lot of questions. This is not abnormal. And what I've done in the past with pretrial motions, I would ask a lot of questions to both sides to give them the opportunity to flesh certain things out. And for the
Okay, I must ask. You say the sound is fabulous? I was just about to ask about the sound because it looked like his mouth is moving and the words are not matching. But let me know, because I was like, well, maybe I need to refresh it because he sounds like his mouth is moving and but let me refresh.
It's not going to be a full-on just argument. It's going to be a lot of questions. This is not abnormal. And what I've done in the past with pretrial motions, I would ask a lot of questions to both sides to give them the opportunity to flesh certain things out. And for the things that I care about, considering those are the things that I have to make the final decisions on. So with that being said, and I also said, I forgot that I will also give the defense, considering it's their motion, that I'll give them 10 minutes for rebuttal at the end for whatever points that they feel they need to clear up from whatever the state said. So with that being said, we will start with the defense. You can start with your arguments, and then, like I said, at some point, I'm going to cut in and start asking you specific questions. So go ahead.
Yeah, understood, Judge. We were actually planning, based on what Your Honor just represented, to submit on the papers.
So you have no questions? I mean, you have nothing else you want to add?
Our submission was lengthy and it was comprehensive. Based on it being incorporated into the record, we didn't intend to make any supplementary argument.
All right. Well, then I'm going to ask you a few questions to make sure that I understand what you're arguing.
Yes.
So that we're on the correct page here. So in looking at, let's start with point one. Okay. So the threshold question, really under State versus O'Brien, was whether the challenge conduct had the capacity to unfairly influence the jury. And really the question is that whether whatever happened between the court and counsel, whether that was observed by the jury or not. The defense's brief.
Oh, y'all hear that? He's talking about when him and Sparky was getting into it in front of everybody. Let me see if Court TV's feed is better. I don't know. It sounded like it seemed like his mouth is moving, but he like I don't know. I don't know if I can do this because it's like a on my end. It looked like a
Very redundant at all.
like
I mean, it was.
mouth is moving without anything going on, and it's gonna drive me bananas. And yeah, so let me see if Court TV.
All right. So I had my law clerk send an email to you all so that you would have a good idea the way that I wanted to structure this motion, making sure that counsel had enough time to.
Defense as well is how.
Stand is
No, I guess we are keeping it at law and crime because that one is no good either. Okay.
whether the challenge conduct had the capacity to unfairly influence the jury. And really the question is that whether whatever happened between the court and counsel, whether that was observed by the jury or not. The defense's brief identifies several different instances of what went on between the defense and the state. To include the day 17 exchange, which the brief describes as most inflammatory, the Palucci sidebar, the Flanagan sidebar on January 15th, the February 9th exchange, which your brief characterizes as a public accusation of a discovery violation, and the credibility commentary during the February 10th argument. All of those instances did not occur either in the jury's presence, meaning that they were not even physically in the courtroom, or happened at sidebar. So what I'm trying to understand is that based upon what your arguments are in your brief, can you walk me through your theory on how those incidents that the jury did not observe, how they actually could have impacted their ability to be able to decide this case fairly?
Well, one thing that's pointed out, I think certainly by the state and by defense as well, is how
where I had to tell them to please quiet down. Putting all that together, how do I come to the conclusion that they would have seen, or they were so focused or hyper-focused on the sidebars that it would impact their ability to be fair and impartial?
Well, I think that the dynamic that was at play during the trial is, and, Your Honor expressed this during the course of the proceedings, not to the jury themselves, but to the parties that, it's important to, for the court to, in essence, keep things light to an extent, because the gravity of the proceedings was so serious that it was important for the court, I think in Your Honor's words, to keep things light so that the jurors wouldn't feel an undue burden in their service. I think that was what Your Honor's sentiment was. But to juxtapose that, right, the kind of lighthearted aspect of the court's dealings with the jury, with what I think they would have been able to see as they were, at times talking, but at times looking at the court during sidebars, what they'd see is a juxtaposition of that lightheartedness with, I think, what was visible frustration on the court's part in just reacting to the parties, specifically, I think, Miss Mastalone, right? And it appeared to me that it would have been obvious to anybody looking that Your Honor was frustrated, Your Honor was annoyed, that
You would agree with what Alabama says, the case that you cited. That let's assume that you're correct, which right now you're speculating. The only thing that you have said so far, out of fairness to you, is that it appeared to me that they would see this. But it's not like you were standing there staring at the jurors and they communicated with you in some way. It's not like you have any documentary proof that actually there was some impact on them. So my question to you is that in using the case that you cited in your brief, how is it that you are taking the leap of saying that because you saw something in the court that it should be impugned upon all of the jurors in this case throughout the trial into the ultimate deliberations and the conclusion of this case, meaning their verdict? I'm struggling how you keep that causal connection between all of it.
Well, I understand the court's question. Obviously, as the court said, we don't have a letter from a juror saying, here's what overwhelmingly decided my verdict, not the evidence in the case, but the demeanor of, the court. Correct. But I can only say what I witnessed, and I can only say that I think both parties here agree and placed in their submissions that this was a jury that was very attentive to the court. I think a jury that felt a rapport with Your Honor over the course of the trial. I think that was something that, Your Honor expressly stated, wanted to cultivate to an extent to keep this situation, as Your Honor said, light, and it's understandable. But the one of the results of that is that I think the jurors were, very much looking to Your Honor during the course of the proceedings. And they were able to see what was happening in sidebar. I understand Your Honor's question. How do I ultimately connect those dots? Ultimately, I don't even think I'm the person to, be the arbiter of that decision. I can only point out to Your Honor what we believe was taking place, what we believe was observable, what we believe the jury in all likelihood did observe, and what we believe based on that dichotomy of the, kind of more friendly rapport that Your Honor had with the jury versus the appearance of, I think, frustration and anger with defense, That dichotomy is the thing that we think creates the problematic atmosphere.
Okay. I'm not sure. I'm gonna move on from this, but I'm not sure I agree with you that I had the emotions that you are qualifying me to have. But either way, even assuming you are correct, we have nothing in this record to say that what your classification of what I look like is anyway before this jury. It wasn't provided in an appendix. It wasn't provided in Court Smart. I reviewed the entire trial all over again, which in Court Smart from this courtroom, you actually can see all of it. Not just the audio record, but the visual record of it. And I didn't see it, but let's move on from there. Now, your brief raised no objection to the jury charge, which expressly told jurors not to speculate about sidebars, not to consider court counsel interactions for any purpose, and not to treat my rulings as favoring either side. That jury charge went over 5 different times. Ultimately, it was confirmed by the defense on February 10th that there were no issues. So if you were in agreement with the instruction given at the time, you did not raise an issue with the instruction in your brief. And our case law under State versus Feaster 156 NJ 1,65 1998 presumes that jurors follow instructions. So what does the court have in the record to prove that the jury didn't follow those instructions?
Of course, there's that presumption. I think one of the things that within the brief is maybe worth talking about in that regard is the theft and misapplication of entrusted property charges that the jury had to consider. I think the reason why we bring that up in our brief is because the state explicitly told the jurors to just essentially find a 3rd-degree theft. They even put in their slides that the theft amount was under $75,000. There was no commentary by the state in closing as to how this could be a 2nd-degree theft. The jury was basically told, this is a 3rd-degree charge. Find a 3rd-degree charge. They still came back with a finding of guilt as to the 2nd-degree offenses. And our brief states it as demonstrably the jury having such an animus by the end of the trial for Mr. Caneiro that even with the state telling them to find the lesser offense, they still found the greater. Now,
you would agree. I'm not going to make the left or the right turn with you right this minute to talk about that charge, which we could. But you do agree with me that a jury decides what the evidence is in a particular case. And it doesn't matter what the prosecutor says because that's not evidence in this. At the end of the day, it's up for the jury to make that final determination. We can agree on that, correct? All right.
Yes.
So I understand what your point is, but I don't want to diverge from my question. My question really is, under these circumstances, because there's no objection, because specifically in this case, and I know you know this, that the court went not just to the model charge as it related to sidebars. It allowed the defense to provide language, and the court accepted that language and read that language to the jury. So as it relates to sidebars and the explanation of things. So, and other than that, there was no objection to the charge. So that's why I'm coming back to the argument, which is if all of that is true and there was no objection to it, where are we now? how do I presume anything other than the jurors followed the instructions that we gave them?
Well, Your Honor's correct. We did ask for that charge, and not to rehash arguments from earlier, but we did ask for that charge based on what we perceive to have been happening over the course of the trial.
Right.
And you know, we appreciate that Your Honor agreed to give that charge to the in terms of a presumption that the jurors did not follow the instructions of the court, that they misconstrued elements of the offense, that they didn't base their findings on appropriate the appropriate legal standard. All that we have, right, in that regard, we don't have affirmative information from the jury. I don't think in situations like this, it may not very often be the case that a reviewing court has such information. All we have is, to some extent, the course of how things played out over the entirety of the trial, and the merits or lack of merits in saying that this could have impacted the outcome. And I don't think we can, get to a situation here where we can say presumptively the jurors did not follow instructions. All we can do are point to things that may indicate that the jury was soured on the defense, was less likely to consider our arguments seriously. And that's, with that argument, Judge, I think incorporates more than simply the interaction between the court and the defense. That also goes into issues relating to the state's closing arguments. And so, but all of these things, I think, can be considered together, right? Because when you get to the possibility that cumulatively there's an issue, I don't think that cumulative review requires in any sense that we can establish affirmatively a presumption that such a thing is established as juror disregard of the law, but that cumulatively in total, that the issues related to point one of our brief combined with the issues related to our point two regarding the prosecutor's closing statements, and all these things together can be considered in terms of whether the result of the trial was not the jury just straightforwardly listening to the evidence, but whether these outside factors had the probability of impacting the result.
I understand your point, but the problem is twofold the way I see it, and it may be more than that. Under State versus Williams, 93 New Jersey 39, 63, 1983, to overcome the burden that you have as it relates to this particular issue, you have to have some affirmative information. What you have is speculation. So if you only have speculation that you're putting these things together and saying, okay, well, when you look at these things, because it smells bad, it must be bad, that's not the standard. So even when you go to the cumulative errors point, your point 4, if the underlying facts are not substantiated and they're only speculation, they can't be considered for the cumulative error. And I'm sure the case law is clear. I can go find that case for you too. But the reality is that that's what I'm told not to do. So from where you're coming from, I get your point. I get what you're saying, but there's a reason why I think, based upon the case law and Feaster, why it's stated the way that it is. If you don't have any proof to overcome the burden, then the lack of proof under these circumstances, the no juror affidavit, the no post-verdict statement, the no juror note, the no communication of any kind to the juror, that's zero affirmation of rebuttable evidence in the record to support what you're saying. So I understand where you're coming from. I'm not going to belabor the point. That was my question that I had for you as it relates to that particular issue, and I appreciate that. My next question for you. Let's talk about the issues, some of the other issues that happen in front of the jury. Okay. In each in-jury intervention, your identification as you identify in these circumstances that the court either sua sponte formed its own objection to these questions. When I reviewed the record, those interventions did not arise in a vacuum. During Detective Brady's cross-examination, the witness had already answered the point multiple times. During Detective Miglorisi's testimony, the question called for the information outside the witness's personal knowledge. And with respect to Detective Bassinger, the record does not appear to reflect a whole sua sponte intervention as your brief suggests. Because if you look back on the record and you looked at the video at the time, and that was your witness, so you may not have seen it, out of fairness to you, that the prosecutor was standing up and his arms were in the air, and I sustained the objection. So it was, the prosecutor was standing up and I was responding, but was saying that. So am I correct in saying that as to these instances that we're talking about, these three, the defense is not really challenging the validity of the rulings themselves. However, what you're challenging is the way it happened, the procedure in which it happened, meaning that I stepped in before an actual objection occurred. Am I correct?
That's my understanding of the argument. Yes.
Okay. So that would really go to, tell me if I'm wrong, because that's why I'm trying to create the record here, is that, so that would really go to the demeanor of me in front of the jury. That's what you're talking about?
Well, certainly that, that it also wasn't a situation where during the course of the trial, I mean, obviously the defense raised objections to questions that the state was asking, and sometimes those were overruled, sometimes they were sustained. Your Honor made, decisions in that regard, but it was only the defense that had questions sustained in terms of the court's findings prior to, and sometimes in the absence of the state raising any objection. And so the perspective we have on that is not just that, yes, that was the court inserting itself into the proceedings, but that it was kind of a lopsided way of doing it, to the extent that it is not something that happened where the state would ask a question. And I think sometimes they would ask outright objectionable questions, and, but Your Honor would not sustain its own court's own objection, except in instances when the questioning was being done by the defense. And so I think that that's important to bear in mind. And obviously, Your Honor is extremely well versed in criminal law. So, it was also clear that sometimes the state was had objectionable questions. So that's why we thought that was noteworthy.
Okay. So, and I understand where you're coming from. However, so that we're on the same page here, is that when I'm doing the analysis in the opinion for this motion for a new trial, I'm going to be addressing it as to the form of my demeanor because there is no objection to the underlying validity of the court's ruling. So we're dealing with my demeanor. So I'm going back to the analysis under Allen versus Alabama and some of the cases there. And I'm going to look at, so that you know exactly what I'm doing, that I'm going to look at those interactions and how they actually occurred and what was going on during the course of that, those particular questions. Because when you do that, there are times where I say to move on and people are not moving on, meaning the defense. And then that creates another sustained objection that may not have been objected to right in that question. But when you look at it in the context of an objection did occur, I sustained it. And then counsel decided to do the same thing, even though I've already told her that the objection was sustained. So that's where I will draw that balance of looking at my demeanor as it relates to the conduct that was happening in front of me. And I believe, I think you'll agree with me under Rule 611A that I have to make a determination and I have to keep the trial moving in a purposeful way. And if people are not responding to the court's decisions, then the court may have to do something about that. Do you disagree with that?
I think you have wide latitude there.
Okay.
But
You think I went too far?
yes. I mean, in some respects,
Mhm.
in some respects I did, but I,
Which one?
well, I think with Detective Brady, I thought that, my recollection of it was that it was a bit, I think it was pushed a bit far between the court and Ms. Mastalone. I think that she was asking questions that ultimately, were not objectionable. I think they would have led to admissible testimony. I think Your Honor had, for whatever reason, with the personalities involved with this case, that by that point in time, I think Your Honor did, to me, it seemed kind of visibly lose patience with Ms. Mastalone during that cross-examination. And that to me seemed to be beyond the kind of what we would generally think of as within the 611 confines of the court's latitude to control the proceedings.
Okay.
And it's not like I'm saying that this was a perpetual issue, of course, of course, with the entire trial, but I'm saying in the moments that it did happen, I think it was very clear, it was very noticeable, at least to me, it was palpable in the room as it was happening. So that would be one such instance.
Okay. So even though that there was nothing written in your brief, that because now you're based on what you just said, is that you think that these questions were okay. That was not argued within your brief. So what you're saying now is that her questions that she asked of Detective Sergeant Brady, or just Sergeant Brady, I should say, you're saying that they were appropriate and that the court's intervention was, one, unnecessary legally, but two, as a demeanor issue, that it's your position based upon your observation of the court that the court went too far. Am I correct? Just so that it's clear for the record.
That's what I'm saying.
All right. So I'll look at that in the way that you're stating it. I'm not sure that I necessarily agree under those circumstances when you look at the entire record and you look at the interaction between Brady and Miss Mastalone. But we'll take a look at it and I'll definitely make sure that that's all part of the ultimate decision. Let's talk for a minute about This is my last question as it relates to just the first point. Your brief relies heavily on State versus Guido, 40 New Jersey, 191, 1963. And I want to make sure that I understand the comparison that you're drawing. In Guido, the trial court publicly accused defense counsel of altering an expert report in front of the jury during open proceedings. And then the prosecutor reinforced that accusation in summation. Those are the two features that made Guido what it was, a public accusation made by the fact finder, amplified by the state. The day 17 exchange here, the one that you describe as the most inflammatory moment in the trial, the jury was not present. And the state summation made no reference to the sustained discovery violation. So help me understand the defense's position as to why Guido is appropriate under these circumstances to draw an analogy to, considering that they're two completely different things. One happened in front of the jury, one happened outside the presence of the jury, which is what we have here.
So I understand Your Honor's point in that regard. I don't really have any commentary on that matter outside of
What's in the brief? All right, I'll leave it alone. All right, let's talk about some of the questions, some of the things that came up in the prosecutor's summation, because I want to make sure that I flesh it out from the defense's perspective, because there was the majority of your brief talks about this particular issue. So before turning to the individual remarks that are challenged in point 2, the defense's brief identifies a number of alleged improprieties in the state summation, but only a limited number drew contemporaneous objections at trial. As to the remainder, including the DVR comments, the state of mind passages, the references, now characterize it as improper, and the financial arguments, no objections were made. When I look at State versus Frost, the absence of a contemporaneous objection is significant, both because it suggests the remarks were not perceived as prejudicial at the time, and because it deprives the court of the opportunity to take a curative action when any problem could have been addressed. How does point 2 overcome Frost when so many of the remarks now relied upon were not objected to?
Yeah, so that's correct. And many of these were not objected to. I would point out that the closing of the state was over 6 hours long. It was accompanied by an extremely comprehensive PowerPoint presentation. In that period of 6 hours, I wouldn't say that it was very redundant at all. I mean, it was lengthy, but it was not largely repetitive. There was a lot of information provided over the course of the summations, and part of defense practice is a determination as to how often and how strenuously one should object, because obviously some things are objectionable and you may not want to draw attention to them for the jury if they're not already focused on it. You may not want to be seen to be unduly objecting. And certainly over the course of a prosecutor's summation, the decision of whether to object at a given point of time, these are things that can be debated. The case law, as Your Honor mentioned, is clear that the lack of objection is an indication, perhaps, that the defense did not have a problem with what was being stated at the time. I can say that is, from my perspective, not the case, that at times the lack of objection was rooted not in a feeling that it was unproblematic, more so in a feeling that it perhaps would unduly draw attention to a matter that if the jury might not already be focused on it, or some of them might not already be focused on it, better to let sleeping dogs lie, as it were.
So I understand that. I understand where you're coming from. But as you also know, when you talk about the 6 hours of Mr. Decker's summation, it was over the course of 2 days. So at the end of the first day, when the jurors were let go for the day, I ask, anybody have anything they need to put on the record? Nobody says anything. That's outside the presence of the jury. Any objection that needed to be made could have been made at that point in time. A motion for a mistrial could have been made outside the presence of the jury at that time. None of that occurs. So the balancing that you're talking about, which I respect and understand, we have a natural break to be able to make those objections, and they weren't done. Let's take it a step further. You have all night to think about it. The next morning, we come back in the next morning. You have the opportunity before we start to put something on the record, make any objections that you want. They were not made. So, and a mistrial was not requested. So under these circumstances, it leaves the court to believe that at the time that the summation was going on, that there weren't other objections. And on top of that is that the court, during the course of the summation, did, if we recall, have a problem with something that Mr. Decker said that was not objected to by either one of you, that I thought may have infringed on the defendant's Fifth Amendment right. I brought you to sidebar. We had a discussion about it. I gave you the opportunity to think about it overnight, because I was going to charge it right then and there. You told me you wanted to think about it. Ms. Massalone came up the next morning and said, Judge, we want to leave it alone. You can handle it with the charge at the end. So I understand where you're coming from. I guess my concern is that it doesn't look good in your record that you're saying you didn't want to over object during the course of a summation because you didn't want to look like you were fearing anything. But at the same point in time, you had times outside the record and you still didn't do it. That's the concern that I have when I'm evaluating this argument that you're making. That's why I wanted to give you the opportunity if there's something else that I may have missed other than what you just said.
Well, procedurally, I don't think that there would be, because what you're can't contest anything that you're saying as far as we never asked for a mistrial. That's true. In terms of placing things on the record at the conclusion of the state summation, that did not happen as far as objections for the record. I think that regardless of that, and that's going to be a consideration for any reviewing court. But I don't think that there's anything I can say about that now, other than that those are facts. And what I think we're trying to put forward in our submission to the court is that there was such a volume of these incidences that happened over the course of what was cumulatively a 6-hour presentation by the state that, regardless at points of whether we should have objected to a particular instance of this taking place, in the aggregate, it's something that perhaps the court had a as the person presiding over the proceedings, to in the aggregate make sure the jury was aware that of such things as the fact that just because Mr. Decker is saying that inserting the idea of, you know, perhaps, for example, Paul Caneiro's testimony into the record, not literally saying that, not explicitly saying Paul didn't testify, but relating to instances of like, well, what was Paul thinking as he was driving home? Only God knows what's being said in that moment between Paul, Jesse, and Sophia. If there's an explanation for why that camera was shut off, I'm not aware of. You know, I mean, but all these things, aside from being burden shifting, I think are just instances of the state basically, in some respect, they're highlighting to the jury, you know who knows those things? Paul Caneiro, right? And you know who didn't testify is Paul Caneiro. And so I think that to do that, not just in a single instance, I think the importance of what we're trying to present in the submission is that in the aggregate, that happening over and over again in these different facets had the ability to come into the jurors' minds in an impermissible way.
All right, let's go to that for a minute. Your brief relies on State versus Angle for the DVR no explanation argument. But Angle itself relied on State versus Gosser, which held no explanation is no more than fair comment on absent evidence. Did the state's summation ever directly invite the jury to ask why your client hadn't testified as it did in Angle? Did it ever go that far?
No, I mean, Mr. Decker's never said specifically that Paul Caneiro didn't testify, nor did I think he invite people to speculate as to why that didn't happen specifically. My only point with the comments about those other instances I just mentioned are that they, I think, naturally lead to a thought in a person's mind as to, well, who has that information? You know?
Listen, I get it. You know, Decker says there is no explanation for shutting that off. Why would Paul Caneiro shut his DVR off at 1:28 in the morning? If there's another explanation for what happened there, I have no idea what it is. The problem that I have with the argument that you're making, though, is that he's not asking the jurors to get into his mind. What he's doing is, I believe, and I want you to tell me why I'm wrong so that I look at it that way, that it's tethered in the physical evidence that what was testified to in the case. And if it is tethered, meaning that the system was hardwired, there was a timestamp, the footage that was involved, that he's saying what he's saying at that point in his summation. I'm just trying to make sure that I understand it from your perspective. When you're looking at this cumulative effect, the problem that I have is that if I'm sitting there during the trial and hearing this cumulative effect as a defense attorney, I'm standing up. You were silent. Both of you were silent. So now, in looking at it in the lens of what I have to look at it now, I'm struggling a little bit for you, Mr. Murray, and that's the reason why that I'm asking this question. And I want to make sure that you have expanded your record the way that you want to, if there's anything else you want to add.
In the grand scheme of things, I'm not sure that a curative instruction in an individual instance of one of these things happening would have been sufficient to overcome the fact that they were repetitive in nature and occurred throughout the course of the entire summation.
Then there's a mistrial application then, right? Right?
Could we have requested a mistrial? We could request.
Well, you're just saying it right now, like you didn't think a curative instruction is going to fix this problem. So then the other form of relief would have been a mistrial motion, right?
Sure.
Okay. So that didn't happen here. So that's why I'm struggling a little bit. But I definitely hear you. I don't want to cut you off. You were in the middle of speaking. If there was something else you want to add as to that, I want to give you the opportunity to do it.
No, I'm just, Your Honor's correct. Obviously, we can ask for a mistrial if at any point where we think that it's you know, it's appropriate and perhaps also potentially likely to be granted. Which is another consideration, one would make and perhaps requesting such an application, but
But why? I mean, you're preserving the record. Even if I disagreed with you, you would have preserved the record. I would have to look at it in a different lens, wouldn't I? At that point?
yeah, I mean, you're certainly correct, Judge, that we didn't. There's not going to be any question on appeal. We did not make that application.
Okay. Perfect. Okay. Let me go to, just for a few minutes, on the issue of, and I'm gonna have a lot of questions for Mr. Decker as to point two, so I'm gonna dive into that more, and feel free in your rebuttal if you want to add anything as to that, you can do that, okay? In looking at point three, which deals with the ex parte written submissions. But to start with at point three, I think the threshold issue for the entire argument is, because everything I think flows from this, is that your point three rests on the January 27th, 2026 order and opinion governing evidence to be presented through Corey Caneiro. He never testified.
So that's me stopping it. I just wanted to pause it right here before he goes to point three. What I'm seeing in regards to, I kind of figured that the defense would do this, with Sparky jumping up and down and the judge having to check her. I don't know how many times he had to check her in front of the jury, but the judge is basically saying, look, you're pointing out my behavior, but you need to show me exactly how does that affect the verdict? How does that change anything with the jury? Did the jury see it? So he's saying that he's going to go back and look at these things to see if maybe something happened. It may be disrespectful, but or you may have felt some type of way. I did tell you to move on many and plenty of times, and you did not, right? So yeah, I think the judges, what they're saying is that the judge indirectly helped convict their client with their brief. So we'll see how that ends up. That doesn't seem like a real good argument, especially if the things did not happen in front of the jury. Now, if things happen in front of the jury, kind of like with the Alicia Andrews case, when we seen a judge doing very snippety things in front of the jury to the defense attorneys, then maybe, just maybe, they may have a problem. And in that case, are you appealing or are you asking for a new trial? Should you have been asking for the judge to step off the case like they did in the Alicia Andrews case and follow those things? I don't know. I think that the motion, the way it's going so far, it looks like the motion is probably going to be denied. I mean, this is a very high bar, and courts do assume that the juries do follow instructions. So you need something major: hidden evidence, clear misconduct, constitutional violation, jury misconduct, things like that. So we'll see how it goes. Let's get back in here.
How does a set of admissibility rulings that govern no evidence the jury received produce a manifest denial of justice?
So that's, I think to answer that question, we would have to go back from the ruling a bit.
Okay.
I think because, and this is laid out in the brief. So to an extent, this is incorporated, but Your Honor had mentioned to the parties months prior to this that a ex parte submission could be helpful to the court in determining the issues related to Corey Caneiro.
Did I say just Corey Caneiro, or did I say, because I didn't know what was coming into this case. I think what I said, and when I say think, I know what I said, which is that if there are legal issues that are going to come up during the course of the trial, that if you want to make me aware of those legal issues with some support, I am more than willing to read that in advance so that we don't have to argue that in front of the jury and or have as many sidebars, which were discussed at certain points during the course of this case, and which we had many of. Isn't that what I said?
My understanding of it was that the aspect of it that was an ex parte letter about issues was in reference to Corey Caneiro. And
in January, what I say to you on the record gives you the opportunity, but I want to go back to December because that's where you originally started. There.
Yes.
What was I talking about? Because how would I have known about what was going to happen with Corey Caneiro? I had no idea. I had no idea the evidence that you had. I had no idea all the things that you were going to talk about until I received the January 19th submission. I had no idea. It was not a part of any motion. It wasn't a part of the case as far as I knew. I had very limited information. I knew from a DNA from our Olenowski hearing, which unfortunately you're not a part of, but during that hearing, it comes up about Corey Caneiro, but I didn't know about any of these other things. So I couldn't have been referencing Corey Caneiro. I didn't know. I was saying any information that you have, you want me to know about it, give me the case law. So you're not saying Judge at State versus Jones. Just classic example during this trial. Ms. Mastalone educated the court on State versus Tier. What happened? The court left the bench, read State versus Tier, came back out, agreed with Ms. Mastalone and the defense as it related to State versus Tier. My point was only if you provide it to me, I'll read it in advance so we don't slow down the trial. Am I wrong that that's the way that the colloquy went with this?
Yes, but to the
Yes, I'm wrong.
No, you're not wrong, Judge. You're correct that that this was perhaps that Corey was to our minds a main component of what we would be submitting ex parte, because that was the specific arguments and lines of cross-examination we would want to bring out during the process of the trial that we wouldn't want the state to be aware of. The defense, as was very clear throughout the course of the trial, was third-party guilt, and the defense very clearly was about Corey Caneiro. So any ex parte letter we were going to submit to the court that we didn't want this is not, an ex parte letter is not run-of-the-mill motion practice. In motion practice, the parties submit what they'd like to the court, and they can see each other's, and the court can evaluate that on that basis. So if it was a 104 or an in limine motion or something like that, it wouldn't be handled in that regard. And so, our understanding at the time was that this ex parte submission, from our perspective, would be about Corey Caneiro.
Okay.
Because that was what was important to us. And I think, we've never seen it, but the state submitted a letter to the court on an ex parte basis. Another thing about it that occurs to me to say now is I didn't realize when we had that conversation that Your Honor was inviting either party to submit something ex parte to the court. I just, and it's not because of anything in particular you said, Judge, but it was just.
You think I just said it to the defense, but in a conference where the state was sitting there? Is that what you're telling me?
It honestly didn't occur to me at the time. Now that you're, when it's happened during the trial, I didn't think that when you mentioned the submission, I thought you were speaking to the defense about providing notice to the court of things that could come up on cross-examination. So I didn't realize that you were talking about party. I understand that now. I'm not trying to say that that's problematic, okay, in that respect, Judge, but I'm just trying to give the court an understanding of what I think Ms. Mastalone and I were thinking at the time when we had that conversation.
It's problematic to me because to me, we were seated all in a room together, having a conversation, and I was discussing it with both sides. That if you have a legal issue that you want me to know about in advance so that I could read the law on it, so we didn't slow the trial down, you could provide it to me. So I'm not sure how that wasn't clear to both sides. I take you as an officer of the court, and that's your position as to what your observation was of that conversation. However, it does become abundantly clear. Let's assume that it wasn't on December 5th when the pretrial conference occurred. On January 12th, when we're standing right here at sidebar, and you look at the sidebar conference, and we're talking about an issue that was coming up where there was some reference to violent tendencies of somebody in the Caneiro family, that it was clear that I was inviting both sides again to be able to provide information. So I struggle with what you're saying, but I hear you. That's your position. I'll note that for purposes of the court's opinion. But I guess my question is, I want to go back to the original question. The fact that Corey Caneiro never testifies in this case, so none of the January 27th opinion becomes part of this case. How then does it in any way, shape, or form produce a manifest denial of justice for the jury to decide this case? How did it happen?
Well, I think what happened was we ultimately, I mean, the defense, or Mr. Caneiro, decided to submit something to the court. That was not, the easiest decision to make, because in the absence of us doing that, I think we would have had the state called Corey Caneiro as a witness. We would have been able to cross-examine him in areas that we thought were relevant and admissible. The court could make rulings as that was happening. And I think for the ordinary witness, right, that's how the proceedings would unfold. It's not such that we have any kind of, obligation to demonstrate some evidence for, say, 404B or
It's just a link. Yeah, it was a link.
Right. So from that regard, we could have proceeded in the ordinary course, and if called as a witness, we could have cross-examined Corey Caneiro in that fashion. By submitting our letter to the court, we obviously notified the court of the things we thought were relevant. Why else would we submit the letter, right? But when we then had the conference on the particular aspects that we asserted in our letter, and we were in court but not on record, the state was able to hear, I think, point by point, all the things that we were interested in bringing out that potentially were going to be admissible if Corey Caneiro testified as a witness. And so it was such that the way this unfolded in terms of the ex parte letter really did not remain ex parte. It came out by virtue of the conference we had on the matter, Your Honor's ruling, and the state was well aware of what we were going to be able to do and not be able to do potentially if Corey testified. And obviously, after that happened, the state chose not to call Corey Caneiro as a witness. And they say in their brief on this issue that, we could have called Corey Caneiro. I think it's obvious from the position of the parties in this case that we never legitimately could have called Corey Caneiro as a witness.
Why not?
Well, because there are some witnesses who are so adverse to one party or another that that party cannot reasonably be expected to call that person as a direct witness in their case.
So let's stay there for a minute. I hear you. I respect what you're saying. But there was two options with, assuming that's the case, okay? That he was so adverse. Number one, you could have called him and asked to be able to treat him as a hostile witness, which under the circumstances with the information, I would have rendered a ruling for you to at least give you the opportunity. I could have done that in a 104 hearing before you even called them. So that would have been outside the presence of the jury. So it wouldn't have impacted Mr. Caneiro in any way in front of the jury. Could have done that. Number two, could have asked for a Clowens charge under the circumstances, explaining to me that under these circumstances, he truly is unavailable, even if you did have the ability to subpoena him, that it was just quote unquote unavailable because of the way that it would come out. Neither of those things were done. So I guess the analysis that I have to make here is, and I think it's a narrow one, tell me if I'm wrong, is really that based upon the court rendering this decision, that it truly just made the state not call Corey Caneiro, because otherwise there was no evidence in this case about Corey Caneiro, other than what was insinuated throughout. And there were other witnesses, I assume, that could have been called. Corey's ex-wife, other people that were in the case that you refer to in your 24-page submission, which includes, candidly, in your submission, it specifically says that it's a January 19th, 2026. It's 24 pages. It's captioned ex parte letter regarding Corey Caneiro. You wrote that caption. The letter opens with the statement that is submitted pursuant to the court's request. That's written also by you. The letter closes by inviting the court to request additional documents if it wanted them. And again, so under these statements that are being made by the defense about this letter is that you're open to the idea of this, to the submission being provided, because it also provided you, the defense, with some information that was helpful under these circumstances to know whether to call Corey or not, because now you had a better idea of the way that the court was going to hear it. And if you didn't like anything or didn't like what the court said, you could always have asked for a reconsideration of what I said. Am I wrong in any of this?
I think that, just to go back to where you began.
Go ahead.
Judge,
Sure.
I think that one issue is that, when we did receive your Honor's ruling, and it was in reference mostly to, if Corey, because I heard Your Honor say other people could have been called as witnesses, Corey's wife could have been called as a witness. Your Honor's ruling, to my recollection, was really strictly limited to if Corey Caneiro is called as a witness. I think in those individual bullet points where you laid out what would and would not be admissible, the preamble to those was, if called as a witness, Corey can be
Crossed on these.
Crossed on. Right.
So it didn't impact whether you wanted to call these other people or not. You could still call anybody that you wanted.
We could call them, but we couldn't. My understanding of the ruling was that we couldn't go into those subject areas of cross-examination that the court was specifically addressing to Corey Caneiro and finding appropriate as to Corey Caneiro as a witness, but not as to other parties, not as to other witnesses.
See, that's what your understanding was, but did you ask for any clarification from me to figure out if there was something that you were unsure of? Because the letter dealt with if Corey was to testify, what was the cross going to be? That's what it was about. So in saying that, you had the ability to still, one, call Corey Caneiro, again, strategic decision, or two, call some of these other people. So my concern is under these circumstances that it was a strategic decision not to do it. And I'm not sure it relates to the procedure that went into this written submission prior to. So I get where you're coming from. I'm gonna take that into advisement. If there's anything else you want to say on that, I'll ask you one or two other questions, and then I'm gonna turn it over to the state.
Understood.
Anything else on that?
No, I think the important point we're trying to get out in the brief is that obviously after this conference takes place, we then see that the state is no longer going to call Corey Caneiro as a witness. And I'm not, saying that we can definitively get into Mr. Decker and Ms. Wallace's head in that regard, but I think the timing of it is worth noting that it very much appeared that they were going to call Corey Caneiro as a witness up and until this point in time where we had submitted our letter to the court where there was a finding as to what Corey could be cross-examined on. And I just want to say as to requesting a Clowens charge, Judge, I don't think that, a witness can be adverse and yet not be the appropriate subject of a Clowens request. Somebody can be a highly adverse potential witness where the bulk of what would be addressed with them in terms of the cross-examination would go to potentially credibility and not necessarily to a reason why the state for exculpatory reasons may not call them. So somebody may not be a Clowens witness, but could still be an adverse witness for the defense. And I think that was perhaps more the situation we were in here.
I understand what you're saying, but that provides, or that analysis that you just gave inserts a judicial decision one way or another as to how it would observe that particular witness. And under the circumstances, that was never even attempted. So that's the concern that I have with what your argument is. And it's as relates to this issue, I understand, I want to be straight with you, Mr. Murray, that I understand this procedure that was applied here. Maybe it could have been done differently. I'm not disagreeing with you. What I'm saying though is that the impact of the procedure that was in place for this case, because again, think of it this way. With the intricacies that were involved in your 24-page brief as to it relates to Corey Caneiro, if I was in a position, I want to make sure you're hearing me. If I was in a position of trying to decide those one at a time, I would have been in a very difficult spot because I would be ruling on one without any idea about the others. And again, you are not required to, as an affirmative defense, to bring this up. I agree with that. But in this case, the way that it was set up and the way that the amount of evidence in this case, if I didn't have something, I could have had rulings that were all over the place. At least with the procedure that was in place, I was giving you everything at once so that I saw it all and I was coming to a conclusion, and then you could do whatever you want with that information. Again, not taking away from calling, not calling, ultimately asking me to reconsider, asking for a 104 hearing on a particular issue or any of that. So that's the struggle that I'm having. But if there's anything that you want to add about that you want me to consider, I'm more than willing to do it. I wanted you to hear it from me. These are my concerns.
Okay, Judge, I understand. I think we did lay out in the brief what the basis of the argument is, and so I'm not going to Let's see.
Okay. All right. Sorry, that's all I have for you right now. Is there anything else that you want to add before I move on to whoever's going to argue for the state?
I just, what I mentioned briefly before, that we still don't have the state's ex parte submission in regard to, I assume it's about Courtroom. I assume that's what they submitted to the court. But we never saw it, and we don't know what was in it. We don't know. It was, as we were preparing our letter, we didn't know obviously what the court had seen, and we had no ability to meet any of that in terms of, if we were aware of it, we could potentially have placed it in our submission to the court. We don't want to clear up any inaccuracies or inconsistencies, but we didn't have the ability to do that, obviously, because of the proceeding. I appreciate your honest comments about this is the way it was handled in this case, and perhaps it could have been handled differently. I understand that certainly, but I am also pointing out that, I think Ms. Mastalone did mention at a sidebar on this issue whether the state's ex parte letter was discoverable. And that issue was never really further explored. And so without having that information, I think that in and of itself, as expressed, was prejudicial to our position.
So let's stay there for a minute. That question was asked at sidebar. Was there any motion that was filed to ask me to turn it over? Was there anything that was stated other than a question that was not brought up in the moment of a sidebar? I think right after that was said, there was a response, something about from the state that, and looking back on it now, that the prosecutor can or cannot talk about what was in their letter. I can tell you it had nothing it didn't have the things that you had in yours. I can tell you that for sure. It had nothing to do with that. And we also have to agree, you tell me if I'm wrong. Shouldn't say it that way. I apologize. That when we look at State versus Fortin and making the determination whether there's some link, it doesn't really come down to whether somebody has convictions or arrests or not. It's the relationship between the defendant and the victim is the link that the court is looking at. Would you agree with that or no?
The relationship between the defendant and the proposed witness. Yeah, I mean, potentially that is, yes. I think that's.
Because that's the biggest link that I have to look at to be able to make a determination one way or another, whether I'm going to allow certain information. And I mean, when you go through the course of the opinion in this case is what we're talking about. It talks about that link as it relates to to the two individuals, right?
Yeah, I mean, I agree that that's a primary concern. A link to the charged offenses could also be a primary concern, but
Okay. All right. Thank you. I appreciate it. Decker, do you have any opening words before? I don't know what your plan was.
Judge, before we got started, I was gonna ask if we could just take like less than 5 minutes, just for the bathroom very briefly.
Sure. Okay, we'll start back at 10 o'clock.
Thank you, Judge.
The session.
Move on to the state.
So it definitely appears that Sparky is not going to say anything. Hey, Ruth, you on your way down here to Arizona? Safe travels. Well, I guess the defense is just pointing out how the judge acted during the trial, tone, frustration, and even his body language. But the judge is basically asking him, okay, once again, how does this prove anything? Y'all are talking about people that didn't even testify regarding my rulings and things. And you guys had, time to bring this up outside of the presence of the jury. Even if you didn't bring it up right then in trial, you could have brought it up the next day, or you could have said something about it. Why is all this stuff coming up right now? So there's that. I don't know. You have to, guys. I'm gonna put a poll in there. Well, I think we do have a poll in there in regards to what we think, but I don't think you should get a new trial. I mean, dang, these people were wasting all this taxpayer money requesting trials and new trials and whatever the case may be. But let's see. I'm not sure exactly if he gives his decision today or not, but we will check it out if he does. Here we go, guys.
Becker, if you have opening words, you can have them now.
Just very briefly, Judge, I was just in reviewing this in preparation. I was obviously reading the defense brief and it kind of struck me as to page 2, the legal argument, the first paragraph of essentially of the brief in support of this new trial. They talk about pursuant to Rule 3:20-1, the trial court may grant the defendant a new trial if required in the interest of justice. Then goes on to define some other terms like miscarriage of justice, which can arise when the case culminates in a clearly unjust result. It's been described as pervading sense of wrongness needed to justify an appellate or trial judge undoing of a jury verdict, which can arise from manifest lack of inherently credible evidence to support the finding, obvious overlooking or undervaluation of crucial evidence, or a clearly unjust result. A clearly unjust result may occur, and thus a new trial may be warranted when the denial of justice results from a denial of due process. And then lastly, in there, I omitted citations. I'm reading from the brief. But lastly, the Dolson case that's cited is whether the result strikes the judicial mind as a miscarriage of justice. And I say that because that's really the relevant standard when we talk about the grant of a new trial. And I think when you look at those words, those definitions, really what they would have to show is essentially a miscarriage of justice and a denial of due process. And none of that occurred here based upon the testimony that was put before this jury, the arguments of counsel, both in openings and closing. We would have had to have been in 2 different courtrooms to be able to say that there was somehow a manifest injustice that occurred in this trial. And I think the last thing I want to say before the court opens up the question, I thought it was worth noting that when they talked about the theft charge, and I know it's kind of at the end of the points, but I think it was sort of intimated that because the court was so nice to the state and how it was so terrible to the defense, that this jury was somehow going to side with the court and just do whatever the state wanted. And I submit that, interestingly enough, while they did find the defendant guilty of every count in this indictment, interestingly, when you looked at the aggravating factors with respect to count 2, 3, and 4 victims, Jennifer, Jesse, and Sophia, poignantly or interestingly enough, they obviously did an analysis in determining, while they found aggravating factors for each of those victims, they actually said no with respect to whether Paul Caneiro committed the murder in expectation of the receipt of anything of pecuniary value. So I think to argue that this jury was just rubber stamping everything the state said because of the way the court treated the defense is just not grounded in any fact. Clearly, this jury was attentive. The court took steps to ensure that this jury was attentive the way the court should have done that. So I find the arguments in that regard to be a little, ungrounded in fact, so to speak. But that being said, Judge, obviously the court has questions, probably mostly with respect to the summation.
Well, I'm going to start with point 1.
Sure.
So in reviewing the record for point one, I want to confirm the state's position on this foundational point here. Each intervention that the defendant identifies during cross-examination of Brady, cross-examination of Migliarese and Flanagan, Artigas, Bassinger, Marino, was preceded by specific evidentiary conduct by defense counsel, either repeated questions after answers have been given, questions embedded factual premises outside of witnesses' personal knowledge, or a continuation of a line of inquiry after a ruling had been issued. Is it the state's position that each of those interventions were grounded in a specific identifiable evidentiary authority under the rules of evidence?
Absolutely, Judge. I think the court talked a little bit about in questioning Mr. Murray with respect to, well, are you saying that the court's rulings were wrong? Or are you just saying the court should not have intervened? Well, I would argue that the court made grounded decisions based upon the rules of evidence. And the court did so in line with its obligation under 611 to control the presentation. Because while the defense, and I get it, and I think the court got it before, the defense made an argument regarding summation and the lack of objections in line with strategy, right? They made strategic decisions, as they're saying today, and we'll take Mr. Murray at his word. They made strategic objections, and they didn't object strategically. So I think the state was doing the same thing. I think the state at times could have, I know the state could have objected more. That was clear based upon the subsequent intervention of the court, which is the court's obligation. I mean, the state and the defense, we do things strategically. Sometimes we feel like, based upon reading the room or knowing our case, we don't want to object when Ms. Mastellone or Mr. Murray ask redundant questions over and over again, because quite frankly, we necessarily may not think it hurts us. But the court's role in that regard, and 611 is clear and the case law is clear, is that the court has an obligation to control that. And the court did so, and the court did so appropriately. But it goes further than that, because there were numerous times, and I know the court recalls, I know counsel recalls, especially in the beginning of the case, where the court brought everyone up to the sidebar with the white noise on, and calmly told counsel that you're not watching the jury. You're not seeing what I'm seeing. They're glazing over. They're getting, you didn't say bored, but I think along those lines. And I'm sure that happens to the state sometimes too. Sometimes we probably bore jurors, but the court is just really providing that advice at the beginning of the trial, which I don't think anyone could rationally argue wasn't exactly what this court was doing, trying to say, hey, you might want to move on. I think they got it, but you're going to lose them. By asking so many questions, you may lose the substance of the actual good point you're making. And I think at times, more than once, probably on numerous occasions, the court even grounded that with, I see what you're doing and you're making good arguments, you're making good points, but I'm telling you that you might want to move on now. That's part of the role of the court as well. Not every judge does that, but under 611, it's clearly proper. And it's clearly part of the role in kind of streamlining things and, quite frankly, offering advice based upon years of experience.
Defense counsel confirmed on February 10th, 2026, there was no objection to any part of the jury charge. The jury charge specifically addressed sidebar conferences, the court's rulings, and the jury's obligations not to draw inferences from any interactions between the court and counsel. Does the state agree that the presumption that jurors follow their instructions established in State versus Feaster and State versus Lofton apply here, and that this defense has no affirmative evidence to rebut it?
I do, Judge. I wholeheartedly do. I think if anything, for the, I don't want to say complaints. I understand what they're attempting to argue, but for all the things that the defense is saying about how the court was so, in love with the judge or in love with the court, or so, attentive and responsive and the like, that even more leads me to believe, sitting here for 7 weeks, watching this jury, because quite frankly, I watch the jury a lot. And I think that was the court's point to the defense, is watch the jury sometimes. and see how they're reacting. But I don't think there's any chance in the world that these 16 jurors at times, and ultimately 12 deliberating, would not be following this court's instruction based upon the interaction over the course of time. I mean, it's just, you'd have to have been, again, in a different courtroom to think that these jurors would not listen to Your Honor.
All right.
Judge, can I just say in that regard too?
Sure.
I think there's case law that's cited by the defense. It's the Mercer v. Weyerhaeuser case.
Right.
And there, it was interesting because the court ultimately granted a new trial. It was a civil case, but they specifically say there's no reason to treat the civil context different than the criminal. But what's interesting about that is, I mean, there's a bevy of instances where the court was particularly rude to one of the civil attorneys every time. Well, you can't do it that way. You can't do it that way. And, you know, one of the things that the court talked about there was like that the judge's repeated instructions that you shouldn't speculate on why I'm treating one party versus the other, you know, that can't affect you. And the judge was really, he was telling the jury that, but it was like almost like it seemed like, I don't know the judge, but it seemed like it was sort of a joke almost, because the issue there really was that the judge didn't allow sidebars. So every instance of the court's, you know, angst and anger with it was a female attorney representing the one party, and it was pretty bad at times, and they listed in the case. But really in that case, it was far different because the jury, we know based upon that record, they heard every single word of it. I'm sure there were things that were outside their presence, but everything that was documented that was inside their presence, you know, was in front of the jury.
As it relates to the sidebars for this case and the way that the courtroom is set up, and from your perspective, you know, Mr. Murray talked about how that from his perception that the jurors would be able to see some emotions that were going on with the court. From your perspective, which was more in line with the court and the jury box, tell us what you saw from your perspective.
Judge, I agree with the court's characterization. And while you were, and I got to be honest, I didn't really think about the logistics too much before coming in today. But the way the court described it, I was thinking about a lot of times how, you know, a lot of times in other courtrooms, sidebar would be to the court's right, and the way I'm standing out to my left. And a lot of times everybody is really looking at the jury. And I think in this courtroom and the way that it was done, first of all, I would agree that the court leaned in a lot and tried to, even if at times frustrated, tried to keep your voice down. And quite frankly, the way that we were situated most of the time, it was usually Ms. Mastalone to the court's far right, Mr. Murray, Ms. Wallace, and then myself all the way to the right. And quite frankly, I'm not so sure how much this jury could see through me and or Ms. Wallace, but in particular me. So obviously the white noise, and I agree, I thought of the same thing. There were times when the court actually had to stop kind of sidebar and say, hey, can we keep it down over there? I mean, obviously they all got along. We saw it. I mean, I think everyone saw that that jury ultimately, you know, talked a lot and they spoke to each other a lot and seemed to get along very well. So I think when this court with this jury, even though this is an argument they're making, this court with this jury, I think that I can't imagine a scenario where if you told them to disregard something, they would not disregard it.
All right, let's turn on to point 2, and it deals with the state summation. All right, let me start with the comment that the court sustained an objection to. It was your remark that there was only certain things we can elicit from witnesses that's actually admissible, suggesting to the jury that additional damaging evidence existed but was withheld by the rules. That comment, standing alone, is concerning. It implied the record was incomplete in a way that favored the prosecution. While I sustained the objection and I gave a curative instruction, my question for you is straightforward. Can you articulate why that comment in the context of the full 6-week record does not rise to the level of requiring a new trial under Garcia?
I think part of the law, when you look at summations and prosecutorial misconduct, a lot of what the courts have recognized is that the prosecutor is expected to argue vigorously and, with passion and the like. So I was wrong. I stand here and I may have even said it then. What I said was not legally justified or under the rules. That being said, I kind of stand here and plead not guilty with an explanation, I think, because of the fact that Miss Mastalone in her.
Plead guilty with an explanation or
Yes.
not guilty with an explanation?
Not guilty, I should say. No, I guilty with an explanation. You're right, Judge. I got to figure the two out. But what happened in the defense's summation, Miss Mastalone specifically told this jury that Ben Paolucci didn't say anything bad about Paul Caneiro. Now, the testimony obviously was about Ben and Keith getting together on that Saturday night before this happened, and they looked for jobs through Ben's Amazon profile, and then they went out to dinner. Now, while I was wrong in what I said in summation, I was right in the manner of presentation of that witness. I did not ask certain things because I knew they were improper hearsay, the same way Ms. Wallace did with other witnesses. But then to speculate in summation that Ben didn't say anything bad was, first of all, based upon the testimony that was heard, was not really true, because he did tell him to stop worrying about Paul and start worrying about yourself and your family. But what, I put in the brief, and it's not really part of the record, but it's just to point out the fact that I felt an obligation to correct what I thought was a misstatement of fact and argument by the defense. And unfortunately, I felt, I guess at the time, that the only way I could really do that was to just simply explain that sometimes there's other things that you can't hear. Improper, I mean, yes. Do I think it was a fleeting comment? Yes. Do I think in the scale of a 6-hour, God help me, summation that it mattered to this jury? No, particularly after the fact that the court told this jury to disregard my comments. And I would note, Judge, I believe that is the only sustained objection in the entirety of the summation, unless I'm wrong.
No, that was the one. The defense argues that your repeated emphasis that there was no explanation for your client shutting off the cameras constituted burden shifting. The court's view in that State versus Gosser controls, and that fair comment on the absence of evidence is not the same as a direct comment as on the election not to testify. However, your summation on this point used the phrase no explanation multiple times and culminated in, if there's another explanation for what happened there, I have no idea what it is. At what point, in your view, does repetition of a phrase that is permissible in isolation risk crossing the line into impermissible comment on silence? And do you believe you stayed on the right side there?
I do, Judge. And I know you brought up earlier somewhere where you thought that I may have skirted the line on day one with respect to invocation of the right to remain silent. And I don't.
You're talking about summation.
Yes.
No,
Is this the same
I'm
thing?
talking about in the defense's brief.
Yeah.
They were talking about times that there were no explanation, especially as it related to the DVR.
Yeah.
And you make the comments that you make, and then you made that comment more than once. So my question is, in isolation, maybe not an issue. If it's happening more than in isolation, where does the court land on something like that? Because where does it cross the line from being proper to going too far?
So I don't think it's anywhere near it, Judge. And I don't think that comment could ever be looked at as infringing or kind of getting close to the line of comment on his right to remain silent. And I say that because what I also talked about and what the jury heard during the course of the trial was all the things that Paul Caneiro chose to say about his cameras. So you don't have a right to remain silent. You have a right to remain silent, but when you choose to speak to the police, those words, obviously we had hearings on it and they were under 104. The court allowed those statements in. And quite frankly, I think, and I could be wrong about this, but I don't think I am. But when you say certain things to the police, okay, I don't know if I shut them off, or I've had problems with my Wi-Fi and the like. Sometimes what you don't say is also relevant, and it's not the right to remain silent because it's in the context of when you chose to speak to the police. So I personally, I think those comments are what I made with respect to there's no explanation. I kind of looked at those kind of the same way as like the God references that the court will probably ask me about. They're colloquial, like it, and quite frankly, as I said in our brief, page 11, how could I be faulted? They're arguing that I shouldn't have said there's no explanation because, I'm commenting on silence, but yet in the brief, in summation, they provided an explanation. Like, it's not like this was like, it was never touched and it was never referenced by the defense in summation. And all of a sudden there's no explanation. There could be no explanation. They provided one. It just, quite frankly, wasn't good. I mean, and that's really, I think, why I needed to be repetitious at times, because they were giving that. They were arguing about the Wi-Fi, which the testimony was, I think, fair comment, and I believe I said it in summation, but we're talking about Wi-Fi, and the only testimony about that, I think, whether it was from an email or message or the actual testimony of a witness, was that the Wi-Fi was used to access via like a cell phone or a tablet, the actual hardwired footage. So like, that's where Wi-Fi came in. We had a picture, there's a power box that's connected to that DVR. And I referenced the exhibit number in the brief, but I just think when he chooses to speak about the cameras, chooses to make explanations and excuses, me arguing that there's no good explanation other than what they saw, I don't believe is anywhere near improper, personally.
During the summation on February 12th, you said, in the context of arguing that Corey Caneiro had nothing to do with the homicides, I shouldn't have to prove that to you. Defense objected. I overruled the objection at that time. On reflection, that phrase is imprecise. Taken literally, it sounds like the state is disclaiming its burden. However, you immediately followed it with evidence-specific arguments that Corey was eliminated by the physical evidence. My question to you is that if the court was incorrect with that decision there, and I'm not sure that I am based upon the overall evidence in this case, but let's just assume that I was for purposes of the defendant's argument. Tell me how that impacts the overall decision by the court on whether that there was misconduct in the summation.
Judge, I think it was abundantly clear. And I think, if the court was wrong, let's just say for a second, which I don't believe it was.
I'm not saying it either. I'm just saying if.
Sure, if. I think that the comments and clarification thereafter, would cure any potential wrong that was, misperceived by that comment. I think at the end of the day, the state was clear to the jury that it had a burden to prove the defendant's guilt beyond a reasonable doubt. And ultimately, when we talked about third-party guilt, I was just saying I shouldn't have to prove that Corey didn't do it, which the court gave the third-party guilt charge, which I recited in the brief. But that involves really whether or not Corey Caneiro's presence in this case and in defense arguments would in any way detract from the state's ability to prove Paul Caneiro's guilt beyond a reasonable doubt, which I think was firmly established. I hope that answers the question.
I get it. All right. Your summation included passages describing what the defendant may have been thinking about after the murders. God, what I just did to my niece, and the suggestion that he never knows how that you never know how you're going to react after something like that. Defense argues this was an unqualified lay opinion on the defendant's mental state. You then immediately added, none of us know. You argue that and framed it you're arguing it now and framing that as a rhetorical rather than evidentiary, but you do have the obligation to prove intent beyond a reasonable doubt. And the defendant did not testify. So some of those comments that you're making about including God and other things that you said potentially went to the defendant's thought process that was not in the record. Tell me your overall opinion as to that, as to why you did not go over the line as it relates to that issue.
The defendant's thought process, Judge, unless he makes statements, which he did in this case, obviously, but they're not relating to that specifically, they're never in the record in case unless the defendant testifies. I mean, that's why I say to the jury charge, purpose and knowledge or states of mind, they can rarely be seen or heard. That's the point of fair comment in a summation. What I'm saying to this jury, or what I was saying to this jury was, this guy just murdered 4 people, including 2 kids. I'm actually, quite frankly, calling him a human and saying it had to have affected him in some way. And the argument essentially was in response to the most major point in the defense opening and in summation, and probably the best point they make. I mean, it ultimately it wasn't going to work, in my opinion, based upon the evidence. But the best argument that Ms. Maslon was making was that why would this guy kill everybody, bring the evidence back to his house, start a fire, leading the police and fire to his house to find the evidence? And the answer to that is, after you kill 4 people, including 2 children, you're not always thinking right. And I mean, that's fair comment based upon the nature and violence of these effects. And it went to the fact that he may have been less sloppy in the beginning because he left his phone at home and things like that, but he was sloppy. And the reason why he was sloppy, based upon the evidence and the inferences that can be drawn there and from, was because these types of things affect anyone. So, Judge, I don't think personally that there's anything near. I think that's wholly fair comment. And I think all you have to do is look to how many times this court and any court in these cases charges the jury on purpose and knowledge.
So would you have handled, in looking at it back now, would you handle that any differently?
No. Maybe, Judge, honestly, maybe I would try to refrain from the use of the word God, but obviously, you know, they cite to that, and I was like, oh, okay. And then, you know, I looked it up thinking there was some case law in that regard, and I think maybe I thought there was. I just didn't quite find any other than the cases that I cited talking about colloquial references. I think the argument that's made, and there's a case somewhere because I heard about it in the past, but couldn't find it, and they didn't cite it, was the evoking God in order to have the jury hold someone accountable for, you know, these types of, you know, religious, you know, wrongs and that sort of thing. And that's not even close to what was going on.
Okay. All right. Let's look at, I want to continue on point 2, and I want you to respond to this directly. Defense counsel says, even if no single comment independently warrants a new trial, the cumulative effect of the DVR language that I shouldn't have to prove, the admissible evidence comment, the state of mind evidence passages, and everything else that you said in your summation, when you consider that all together, it substantially impaired the defendant's fundamental right to have a jury fairly evaluate the merits of the case under Garcia. Tell me specifically why you disagree with that.
Judge, because I haven't yet conceded that any of those comments were improper as of this point in time and the court's questioning. I mean, that would really be my answer. Other than, you know, when the court sustained the once objection, I was wrong. I acknowledged it. And I think, quite frankly, I know we talked about this earlier. I don't know if I said it, but I think, you know, the reason why personally, Judge, I don't mind if someone objects during a summation, because it is a reminder when you get in the moment that sometimes things come out of your mouth that, you know, you may not have thought through entirely. And it's a good opportunity for the court and for the state to then clarify. That being said, a lot of, when we did have objections, I think even when the court overruled their objections, I still gave it thought and attempted to clarify just to ensure that I wasn't saying what maybe they thought I was saying, like with Jennifer's phone. That's not, or with Elisa's phone. I know that was one of the comments. Because that's not what I was saying. And I could see reading a transcript or something and the logical progression of what I had just said. I could see where they thought that. I don't necessarily, I'm not arguing with them on that. But then I was able to clarify that I was talking about there's nothing there to suggest that Corey Caneiro had anything to do with this, not about Elisa's phone.
Do you disagree that during the course of your summation, it was over the course of 2 days where there was time outside the presence of the jury for both sides to be able to put anything on the record, either at the end of the day or the morning of the next day?
Oh, absolutely, Judge. And that's happened. I mean, usually at the end of a summation, the court invites parties to come up like you did.
It's at the end of the jury charge or at the end of trial or a
Summation? I mean, clearly at the end of the jury charge, but what I'm saying is at the end of summations. I mean, that's happened to me any number of times.
Okay. All right. But for purposes of this case, the way that things played out, considering that your summation was over 2 days, we had the end of the first day and the beginning of the next day.
Correct.
Have discussions, and then the jury went to lunch before the court started its charge in the afternoon. Is that correct?
Absolutely, Judge.
All right. You don't recall that any differently?
No, I do not. I do not at all, because that's what happened. We finished summation before lunch. I think our lunch break was like, I want to say it was like an hour and a half. I feel like we got done at 12 or something along those lines, and then we had till 1:30 when the jury came back and the court started the charge.
All right, let me go on to point 3 to discuss this. So, Mr. Murray brought up a point that I want to discuss with you. It relates to the understanding of these submissions, the written submissions that I indicated could be supplied. Can you give the court your recollection of that conversation of when it was conferenced about what was said during the pretrial conference?
100%, because while I didn't file I'd be happy to turn it over. I just thought that ex parte submissions generally don't get turned over. That's why I haven't yet.
I'll ask you about that in a minute.
Sure. Now, when I put in my brief, I think I cite to the date, it's December 5th or 8th. I forget exactly when the conference occurred in chambers, December 5th. So ever since that point in time, the state, myself and Ms. Wallace were discussing the idea of providing something, which we ultimately did on January 5th. That being said, the court, and this wasn't the first time the court said this, it was a little more directed this time, a little more like, it was a little more thorough this time, but there have been previous conferences where the court had said, remember everybody, I don't like to be surprised. I would like to be able to rule outside of a vacuum and have the information so that I can make the right ruling. So ultimately the court was talking to the defense. I mean, it was more directed at the defense. Hey, if you want to provide something, I know I get strategy, all that kind of stuff. You don't have to give it to the state. You can just give it to the court. And then you said, and the same goes for the state. I think that's verbatim what you said. And if it's not verbatim, it's really close. That is absolutely my recollection. I was able to look in my calendar and go back and figure out exactly what day that happened. The conference was, I think, exactly a month before trial. So that is verbatim what this court said.
The court acknowledges that the written submission procedure may not have been the only way to handle these issues under the circumstances. But why does the procedure as it actually occurred fall short of producing a manifest denial of justice, in your opinion?
Judge, let's look back to the date. I think it was a Friday, I believe. where we argued after both sides had submitted.
Friday afternoon
And then I think on Monday, the court issues its opinion.
or Tuesday, one or the other.
The opinion was like 40 some odd pages. I don't have it in front of me, but I did review it. To imagine that this court or any court would have had to make those rulings individually with individual questions in that vacuum as you went along with a witness like that, or quite frankly, it's actually become obvious as to the difficulty of some of those decisions. And it become obvious like in days prior to we argued it when certain things were elicited or tried to be elicited, does he have any violent criminal relatives or whatever. So just to think about if a review in court were to be listening, to look at the volume of what the court ultimately had to decide and how thorough of an analysis it had to do. Let's just think about what would have happened had the court had to make those decisions in the middle of trial. This jury would have been downstairs for hours on end. That's the reality in my humble opinion. So I don't know that there was any other way. I chose to listen to the court and submit something. I don't know what the court thinks of what I submitted, but it was basically like, Judge, I don't know what they're going to do. I don't need to know what they're going to do. But some of these things, I think if they're going there, they're not admissible or they require a motion or whatever the case may be. That's basically, I think, what I was saying in a heartbeat, citing to rules, evidence rules.
Look,
And I think
it's up to you. I'm not going to say one way or another as it relates, because Mr. Murray brought this up at the end, that he's never seen the state submission. That's
So I just didn't know if it was appropriate to provide an ex parte submission, but that's fine.
So the January 4th letter, just for the record purposes, was just handed. Again, I mean, that doesn't change the fact that they didn't have it at the time. However, they can see it for what it was. And I'd like to communicate about it now for a second, considering that that you just turned it over. That letter, and you should just started to characterize it, really did not go into any of the factual scenarios that was supplied by the defense in their submission. Is that fair?
I'm going to agree with the court's reviewed both more thoroughly recently than I have. I honestly, they submitted theirs. I really wasn't all that concerned, to be honest with you. I was more concerned about the process, the procedure that they were complaining about. I'm sure at some point I'll review that more thoroughly, but I know.
Let me ask you this, because you know what, let me just stay there because that's a good point before I even go any further. As an officer of the court, you have indicated that you did not see the January 19th letter that was supplied by the defense until March 16th, when it was provided as a part of this motion for a new trial. Is that accurate?
That's accurate. Sure.
And that was the first time that you saw it?
Sure. Yes.
Okay. So in saying that, one of the things that comes up in the state's letter, the ex parte letter, just it dealt with whether Corey had any upper court convictions as it relates to a 609 type of an issue, Rule 609. Am I incorrect that was one of the areas that you were talking about?
I believe that is, Judge. I mean, that's because they kept talking about, prior to trial, they kept talking about, I don't mean this in a bad way. They were just talking about Corey was coming up in chambers. And that's why one of the reasons we had that conversation. And they kept asking me if he had convictions, and I'm only as good as what I have. I mean, certain things don't result in convictions or remanded or whatever prior to this incident. So my understanding was, am I looking at anything that's happened and any prior convictions and then anything that was pending during the pendency of this case? And that's ultimately what would have been done.
So, but to be clear, as far as you can recall, again, I won't hold you to it, but because you just said that you didn't review it the way the court may have. Were you addressing the specifics of what is said in the January 19th letter by the defense in your January 4th letter in any regard?
Obviously, when I wrote that, it was before anyone else before they had written theirs.
But you had the information that's supplied from January 19th in discovery.
Yes, they provided a lot of discovery with reciprocal discovery. We acknowledge that. I think they gave it to us in July at some point. So we had time to review it. And basically, I think I was anticipating issues that I saw just based upon what I had read. And that's essentially, I thought, what the court had asked for from both parties.
Okay. So let me go to there was one issue that's argued by the defense relates to the submission procedure, the way it was set up in these written submissions where the state provided theirs, I believe it was January 4th. We then have the sidebar on January 12th. Where we have a colloquy back and forth where I offer again to the defense whether they want to supply anything they could, but I wouldn't hold it against them if they didn't. That was truly up to them to decide one way or another. And then they supply a submission on the 19th. And then ultimately it's argued on the 23rd. From the state's position, the 15-day gap and or the inability to for either side to see what the other side was arguing, do you, as an officer of the court and your case, do you see that there was any prejudice to the defendant that would meet the standard of a manifest denial of justice?
No, Judge, not at all. I think there was a couple questions or a few questions that arose prior to January 19th of certain witnesses about failure to investigate. I think was along the lines of what they were arguing about. Did you inquire whether he had any other relatives that were violent? I mean, quite frankly, it's just improper, just an improper question. And the argument that was being made in support of justifying it was failure to investigate. Now, failure to investigate became a theme in lieu of trying to say that Corey Caneiro did this, even though thankfully for the first time since this brief was written, Mr. Murray actually confirmed today that the defense was that Corey Caneiro did it. I mean, it was a little bit like, what are we arguing about here? I mean, it was always failure to investigate, but that's not what the opening was. That's not what the summation actually was. So I think, to argue in a different context that like the state didn't have to respond, like we did. I mean, that was the defense. Corey did it. Whether they say it or not, as they did today, that's the defense. So Judge, no, I don't think anything other than Judge, there's nothing in my letter that predates their letter that did anything other than say, Judge, look at 404B or reverse 404B or look at, 601, whatever the case may be. I'm just telling the court, not that the court doesn't know those rules, but just like, that's what I think you should be on the lookout for. That's it. So I don't think there was anything that prejudiced the defense before that, because I think they continued to do it thereafter and they knew what the confines were. I was thinking about it in preparation for this and going back and watching opening statements. One of the things they opened on was Corey's finances were far worse than Paul's. I think that's verbatim. Like, wouldn't you want to know if you're going to get that evidence in? I mean, that's the way I look at it. And the court provided that invitation. Don't you want to know what I want to know what's in? Usually we do, because there are numerous challenges. So we kind of know what we can say, what we can't say. But that's a comment specifically. I don't know that this jury ultimately heard any evidence of that.
This is a question for you to you can answer it, you cannot, but I'm going to pose it anyway. Mr. Murray brings up the fact that the state was definitely going to call Corey Caneiro before the opinion comes out, and then decided not to, just based upon the opinion. At that point in time, you hadn't called him. You hadn't said specifically you were going to call him, that you were still putting your witnesses together. as I understood it. But if you want to answer that question in response to what was just said here today, I'll give you the opportunity to do it. If you don't, that's up to you also.
So I have no problem answering that question. I think the long story short is that we had not made any definitive decisions with respect to whether we were going to do it. Quite frankly, I personally don't think any of this stuff belonged in a courtroom. But the court made certain rulings. I understand why under the law. I just think it's almost like this is, I think the Corey Caneiro thing was, I think it was a big joke, quite frankly. That's the way I look at it, but not from a legal perspective, but from a factual perspective. That's the way I look at it. So, the court, while I think it's couched as the court in that ultimate decision, basically said, you couldn't do this, you couldn't do that, you can't do this. But there's a lot of, you can do this, you can do this, you can do this. And quite frankly, like certain pieces of information would have been probably just as relevant with his wife as they would have been with him. So point of clarification, potentially, like, as the court said earlier, like, judge, can I do the same if she testifies? So, they weren't going to call. I got that sense. If we didn't call them, I got the sense they were not going to call them. And again, I think the court referenced it under the context of strategy. And let's be clear, these decisions that were made in this case were strategic. There is no world where these decisions were not discussed with Mr. Caneiro. Given the abundance of, and I think it's worth noting, Judge, because I think one of the things I said in the beginning was we have to keep in context due process, right? Fundamental fairness. And this court, and actually, it started, I think, a little bit before, or time before, probably Judge Thornton got the ball rolling about Mr. Caneiro's access to discovery. And then ultimately this court, I think, furthered it by allowing, very convenient meetings between counsel and Mr. Caneiro leading up to trial for their benefit. They were asking for it. The court did everything the court could do. I think the jail did everything the jail could do to ensure that they were ready to go. They had spoken to their client, ensured that he reviewed all the discovery. I mean, this has been going on, Judge, for probably like 5 years now. Little did we know when it all started, the beginning of the Mr. Caneiro gets more access than everyone else. I mean, we didn't realize he was going to have another 5 years probably to review his discovery. So, but at the end of the day, like, this defendant was not denied due process. If the court at times maybe got frustrated with parties, okay, it happens. But this man was not denied due process.
Anything else you want to add?
I don't think so, Judge. Thank you.
All right. Mr. Murray, it's your motion. Is there anything else that you want to add?
Judge, since it was provided to us today by Mr. Decker, we would ask to incorporate his January 4th, 2026 letter as part of this motion.
Of course. Mr. Decker, you have no objection to that, correct?
No, Judge, not at all.
We'll do that.
Okay. I would want to just comment on one thing Mr. Decker said.
Go ahead.
At the beginning, when he began to address Your Honor, he talked about the fact that, certain things in the case he characterized as, I think, constructive criticism on the court's part, in terms of, maintaining awareness of the jury, were they attentive to the cross-examination?
He was criticizing me about that?
No. He was saying that was constructive criticism, meant to be constructive criticism.
I think it was, I don't know if it was constructive criticism. It was more in the lines of, I was trying to help the defense is what I was trying to do. As I was telling you, if you remember the words I used, look right and see, because the way that our courtroom is set up, you have to look right or you can't see the jurors because a witness is to your left. So I think those are the words I use, and that was why I'm doing it, but I'm sorry, I didn't mean to cut you off. Go ahead.
Right. The only thing I wanted to point out in that regard is I don't think that the issue that he's addressing in terms of the court, right, assisting the defense with maintaining awareness of the jury is what we're really expressing in our argument. It was more the issue that on really day one of the testimonial portion of the trial, that with the state's witness, Finn Bellucci, I think what happened in that particular event on day one was not the result of, repetitive, redundant questioning on the part of the defense. It was a question about whether there were any questions by the police of that witness as to his awareness of any family members having tendencies for violence. That was it.
So, but here's the problem though, Mr. Murray. I agree that that's the way that happened, but let's remember the end result. I overruled the state's objection and I allowed the question to be asked. So if anything, and we're talking about day one of a 6-week trial, you were allowed to ask the specific question that brought us to sidebar in the first place, right? That's what happened. I allowed Ms. Massalone to ask that question.
Yes, that's correct.
So again, it doesn't, tell me, but again, I just don't want to say anything that you're not saying. To me, what you're really upset about, and your argument really is a demeanor issue. It's not the ruling because I ruled in your favor.
Yeah, I agree with Your Honor. In that instance, definitely, the result of the sidebar was that we were allowed to ask the question.
Right.
Yeah. Anyway, I just, for one thing, I'm just pointing out that was not an objection the court raised to the testimony, to the questioning based on it being redundant or, losing the, attention of the jury because we were meandering.
No, I agree with you on that.
So it was just in terms of it being characterized in that fashion, that was an instance that took place on day one of the testimony. I just thought it was important to reference that in terms of what Mr. Decker said about why the court was interested.
Okay. So, all right. But again, on day one, I'm ruling in your favor, but I get where you're coming from.
Right.
Okay. Is there anything else that you wanted to add?
I don't think so, Judge. I appreciate the court's time today.
All right. Thank you, Mr. Murray. I appreciate it. All right. I'm going to close it for purposes of that. I'll give you some preliminary thoughts, but this is not announcing the findings as of right now. I'm still going to review everything that we just discussed. Rule 3:20-1 imposes a demanding standard that we all know what it is. Throughout my review, the central question has been whether anything that occurred here amounts to a manifest denial of justice, warranting a new trial. That threshold question under State versus O'Brien for Port 1, the real inquiry is what under the circumstances the jurors were able to see and what, if any, impact that they had. Even after oral argument, as I sit here today, the many instances that defense identify, the jurors, I don't see that they could have actually seen it, and or I don't have any evidence to support that they were observing any of it, to include the sidebars where there's white noise and I'm down low talking to everyone. And on top of that, the jurors at times were having their own conversations and I had to talk to them about that. So I'm not sure I really see where we're coming from as it relates to point 1, but I'm going to analyze the areas that were in front of the jury to include the specific comment that was made by Mr. Murray today as it relates to Sergeant Brady. And that'll be a point of the overall opinion. As to point 2, look, there is some of the things that were said during the state summation. They approached the line, but I don't think that they went over the line in a repetitive way as far as I can see it. But I'm going to look at some of the specific things that were discussed here by defense counsel. But I have to look at the controlling question under State versus Garcia, which is not whether individual comments were imperfect, but it's whether the summation taken as a whole so substantially impaired the defendant's right to a fair trial that a new trial is required. I'm saying that at this point, I'm going to take a look at that and from that perspective, and I'll make a final decision. And then as to point 3, 4 and 5, we didn't really discuss, so those to be decided based upon just the written record that we have. Point 3, I look at prejudice. I'm looking at whether what this procedure and this process that was involved here, what prejudice there was to the defendant, and under these circumstances and the procedure applied, and Corey Caneiro never being a witness in this particular case, is a part of that process of whether there was any prejudice or not. So with that being said, I'm going to analyze everything. I very much appreciate everyone's time. I know the defense said that they were going to rely on their brief. I appreciate them answering some questions here today. The decision will come out as soon as it's done, and then we'll move on to the next part of the case, whatever it may be. Thank you all. Everybody have a good day. Please be safe.
Can I ask one clarifying question? I think the court indicated this, but pursuant to the email that the court referenced earlier, just that the briefs are incorporated into the record pursuant to Rule 2.6-182. Is that what the